actually introduced him a couple of weeks ago for another event, and so I think I've memorized his biography. He is a native of Washington, D.C., graduated from Tufts University. The part that I found interesting, he entered military service as a Marine flight officer during the Vietnam War, and flew, I think, over 200 combat missions. Came back, graduated from Cumberland, earned his LLM from Harvard University, and then after graduation, and I think this is a timely issue, he was named legal director of the Southern Poverty Law Center. He practiced law in private practice, worked on a number of prison condition litigation cases here in Alabama, which is actually full circle. We've come right back to that issue in this state. Worked on a number of civil rights cases and a substantial number of death penalty cases, particularly in the 1980s. He's twice argued cases before the U.S. Supreme Court, and then took a different turn, became a U.S. Magistrate Judge in the Middle District for Alabama for a number of years, taught law school at Mercer, and then the way I got to know Dean Carroll is, of course, when he was Dean of Cumberland Law School. I was thinking of something appropriate. That's his biography, but I think it's fair to say, and I think what's proven here, is that when something hard needs to be done, somebody with credibility that's willing to do it and take on the hard task, they have Dean Carroll do it. And I think that's what brought him to this situation of litigating this case in the Judicial Inquiry Commission with Roy Moore. So with that, if you please welcome Dean Carroll.
Thanks very much for the opportunity to talk to you about this very interesting case. Before I get too deep into it, though, just a brief discussion. I certainly did not know a lot about judicial discipline in Alabama before I got in this case, but by way of background, there are two bodies in the state that deal with judicial discipline. The first is the Judicial Inquiry Commission, which is essentially the charging body. That body acts as a grand jury, if you will, to determine whether or not there's probable cause to believe that a judge has committed a breach of the canons of ethics. And then there's the Court of the Judiciary. The Court of the Judiciary is the trial court for matters involving judicial ethics. If the Judicial Inquiry Commission believes there's probable cause to find a violation, the violation's tried in front of the Court of the Judiciary. The Judicial Inquiry Commission also has an attempt at resolution. That is, the judge is given an opportunity to negotiate a settlement resolution with the Judicial Inquiry Commission. So not that many cases get tried by the Court of the Judiciary. The decision of the Court of the Judiciary is to the Alabama Supreme Court. So this case was the second instance where the Chief Justice of the Alabama Supreme Court, Roy Moore, had been charged with and found guilty of violating the canons of judicial ethics. The first, as you may remember, involved the placement of the Ten Commandments monument in the Alabama Supreme Court, a federal order to remove the Ten Commandments monument that was then disobeyed by the Chief Justice. He was at that time found guilty of all the charges against him and was then removed from office. So this was the second time around. This case, as I like to tell Judge Pryor, who prosecuted Chief Justice Moore the first time around, was more complicated. This one involves a very interesting interaction between the powers of the federal courts and the powers of state courts, and revolves essentially around four cases. Two cases from the United States District Court for the Southern District of Alabama, Searcy v. Strange and Strasser v. Strange. A little-known opinion from, except in this case, from the Alabama Supreme Court, the API case, Alabama Policy Institute case, and of course, the United States Supreme Court decision in Obergefell that declared that the refusal of, that you had the right, if you were a same-sex couple, to be married just like anyone else. So that's the sort of background. And then something that flows throughout this case is Article 6, Section 6 of the United States Constitution, which is the Supremacy Clause. The Constitution and laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So the framers of the Constitution said, when there is a conflict between federal constitutional law and state law, federal constitutional law takes precedence. It trumps that sort of opportunity. So, the case begins in January of 2015, when United States District Judge Callie Grenade has a case filed by plaintiffs against Luther Strange and the probate judge in Mobile County named Davis, arguing that the Sanctity of Marriage Amendment and the Marriage Protection Act, Alabama legislation, is violative of the United States Constitution. And in January of 2015, she issues an order saying, yes, that not marrying same-sex couples violates the Constitution. You have a constitutional right to be married. Now, the important thing to understand, and as we go through this, it's sort of a federal courts exam. At that point, Judge Grenade has only one probate judge in front of her. So her order can apply only to that probate judge. That will become important later on. Of course, at that point, the Chief Justice decides to get in the middle of things. Not long after Judge Grenade issues her order, the Chief Justice writes on the letterhead of the Alabama Supreme Court to Governor Bentley, urging him to stand firm against same-sex marriage, and he says, I stand with you to stop judicial tyranny and any unlawful opinion without constitutional authority. So this begins now, this confrontation between the federal courts in Alabama and Chief Justice Roy Moore. Approximately 2 weeks later, he issues a memorandum to the probate judges. He writes them a letter and says that you have to follow state law, which means you cannot issue same-sex marriages. Again, February of 2015. And he then follows that with this 27-page opinion, which is entitled Federal Intrusion Under State Sovereignty. So further this theme about federal sovereignty encroaching on state sovereignty. He then goes on about a 4-month tour where he appears both in state media and national media about his version of why same-sex marriage is so terrible. Now, it's important to note that at this point in time, Chief Justice Moore's view of the law is absolutely correct. Probate judges, except for Judge Davis in Mobile, were absolutely free to follow state law, and he could order them to follow state law. There was no state court order other than with the probate judge in Mobile that dealt with same-sex marriage. This will all change later. What's very interesting is now on the scene comes this very interesting original mandamus petition in the Alabama Supreme Court filed by the Alabama Policy Institute, which is a very conservative think tank based in Mobile. At this point in time, there was no Supreme Court of Alabama opinion that affirmed the constitutionality of the two state laws, one a constitutional amendment, the other a statute, that prohibited same-sex marriage. So all of a sudden, in February the 11th, 3 days after the Chief Justice issues his order to the probate judges, the Alabama Policy Institute files this original petition for mandamus in the United States Supreme Court, in the Alabama Supreme Court, asking the court to declare the 2 Alabama same-sex prohibitions to be constitutional. And that happens. About 3 weeks later, on March the 3rd, the Alabama Supreme Court says the Sanctity of Marriage Amendment, the Alabama Marriage Protection Act are constitutional. So at this point in time, still no real conflict. It's important to remember, state Supreme Courts are absolutely free to reach a different constitutional opinion than either a United States District Court or United States Court of Appeals. Now, the same could not be said of an order. So if a probate judge was under an order from a United States District Judge to issue same-sex marriages, he would be duty-bound because of the Supremacy Clause to follow that order unless it was somehow stated. So this all begins to set the confrontation that will eventually occur. But in March of 2015, when the Alabama Policy Institute opinion comes out, we're not there. Then in May of 2015, Judge Grenade takes the next step. She certifies a statewide class of probate judges. So before her order applied only to Judge Davis. Now her order applies to every probate judge in the state. And it was a very, very well-written and well-thought-out injunction, because she not only ordered the probate judges to issue same-sex licenses, she said they could not follow any decision of the Alabama Supreme Court that was contrary. So her injunction specifically forbade them from following the API decision that the Alabama Supreme Court. She apparently figured out what was going to come, which was that decision was going to be used as some sort of reason why you didn't have to follow hers. She stayed the enforcement of her order, though, pending the decision of the United States Supreme Court in Obergefell. Everybody waited for that. But the important thing about that, and again, very shrewd, Judge Grenade said, look, that API decision that sits there in the Alabama Supreme Court, you can't follow it. That began what we called the game of constitutional chicken. That was a phrase coined by my co-counsel Ashby Pate, who I'll talk about in just a minute. But you had the Alabama Policy Institute decision versus Judge Grenade's decision, who was going to blink. And at that point, there wasn't any problem, because Judge Grenade had stayed her order. Nothing was in conflict. These two decisions existed in the federalism scheme of things. And then, of course, the United States Supreme Court decided the Obergefell decision, which said that state laws which prohibited same-sex marriage were unconstitutional. And Justice Kennedy included in his opinion that they were unconstitutional in all states. That was true of the ruling, but he decided to add that. And so now the game of constitutional chicken is over. Because once the United States Supreme Court decides a matter, state courts, state officials are required to follow that decision whether they like it or not. We'll talk more about the history of that rule. So in July of 2015, in late June, not far after the Obergefell order, the Alabama Supreme Court issues an order saying we'll accept briefing on whether or not we have to follow Obergefell. Who knows why they issued that, but they did. They then got a series of petitions and briefs from people, some people saying you have to follow Obergefell, some people saying no, it's a terrible decision, that sort of thing, you don't have to follow it. At that point, Judge Grenade essentially eliminates the game of constitutional chicken again, which she makes her injunction permanent. So at that point in July of 2015, all of the probate judges are under an order from Judge Grenade not to refuse to issue same-sex marriage licenses. That is the end of the matter. However, some other things happen. At this point, Chief Justice Moore sends a memo to the justices of the Alabama Supreme Court saying you need to rule on whether we're going to follow Obergefell or not. Again, this is a matter of public record. Anything I say is in the record. So this memo suggests to the Alabama Supreme Court that the Alabama Supreme Court doesn't have to follow Obergefell. Chief Justice would deny that it says that, but I think a fair reading of it was that it did. The court does nothing. On October the 7th, the Chief Justice sends another memo to the court saying, you know, this petition has been pending for a while, since June. You're under an obligation to timely rule on things. You need to make a ruling. So he was doing everything he could to get the Alabama Supreme Court to rule, and I think it's fair to say he hoped that they would rule that they didn't have to follow Obergefell. That was clearly the issue, these two memos doing that. The next thing that happens is October of 2015. The United States Court of Appeals for the 11th Circuit affirms Judge Grenade's order. A probate judge had appealed Judge Grenade's order. What's very interesting is after Obergefell was decided, and before Judge Grenade made her injunction final, the probate lawyers representing the probate judges had gone to her and said, look, we recognize Obergefell as the law of the land. We're going to follow whatever injunction you issue and that sort of thing. So at the time that the 11th Circuit affirmed it, they had that information in front of it. But more importantly, a probate judge had appealed her order, saying that it was wrong that they had to follow federal constitutional law requiring same-sex marriages. And the 11th Circuit said, no, the decision of the United States Supreme Court in Obergefell abrogates any state law decisions to the contrary. So you're now in October of 2015. Judge Grenade's injunction is final. The Alabama Supreme Court, the United States Court of Appeals for the 11th Circuit has said, the injunction is fine, we affirm, and folks, that state law decision, API 1, is abrogated by Obergefell. So things are quiet until January the 6th of 2016. And on that day, the Chief Justice of the Alabama Supreme Court issues an order to the probate judges that they are not to follow the Obergefell decision. The order contains a lot of legal discussion about why they don't have to follow that order. But the end is, and this is the part that's in big, bold, black letters in the order itself. It is ordered and directed that until further decision by the Alabama Supreme Court, the existing orders of the Alabama Supreme Court that Alabama probate judges have a ministerial duty not to issue same-sex marriage license contrary to the Alabama Sanctity of Marriage Amendment or the Alabama Marriage Protection Act remains in full force and effect. So January the 6th, 2016, he tells to the probate judges, our decision saying you can't issue same-sex licenses is still in full force and effect. Nowhere in that order does he mention that these same probate judges are under a binding order from a federal court to issue same-sex licenses. He says this decision remains in full force and effect. And at that point, that's what precipitates the major issues in this case. And understand, at this point in time, January the 6th of 2016, when the Chief Justice issues this order forbidding probate judges to issue same-sex marriage licenses, there was a permanent injunction against all of the probate judges in the state that they had to issue same-sex licenses. The United States Court of Appeals for the 11th Circuit had affirmed that decision and said any Alabama Supreme Court decision to the contrary are abrogated. The probate judges' lawyers had gone to Judge Grenade and said, we're going to follow Obergefell. And the Attorney General of the state had conceded that Obergefell was the law of the land and had to be followed. So that's the situation under which this January the 6th, 2016 order occurs. May of 2016, the Judicial Inquiry Commission charges the Chief Justice with 6 separate violations. I am in Minneapolis walking down the street when I get a call from Billy Bedsole, who is the chair of the Judicial Inquiry Commission. And he says, we need somebody to be the lead lawyer in the prosecution of Chief Justice Roy Moore. Would you consider it? And I said, well, you know, I'm a law professor and the summer's off. Sure, I'll consider it. The first person I got to talk to, though, is my wife. I have dragged my wife into some crazy situations involving cases. So I said, you know, is that okay with you? And she said, fine, let's go ahead and do that. So I was then joined by Ashby Pate of the Lightfoot Franklin firm and Rosa Hamlet Davis, who then was counsel to the Judicial Inquiry Commission. And I cannot possibly say enough good about those 2 lawyers. Ashby is absolutely one of the best brief writers that I have ever run into. Ashby did all the heavy briefing in the case. And then Rosa is one of those unsung heroes. She has been fighting in the vineyards of the Judicial Inquiry Commission, disciplining judges for a long, long time. And she's an unsung hero and one of the great lawyers and great people in this state as far as I am concerned. The Chief Justice was represented by lawyers from Liberty Counsel, which is a group in Orlando that represents folks in these sort of religious liberty cases. They represented the clerk in Kentucky that refused to issue the same-sex marriage licenses. What's fascinating is the lawyers that represented the Chief Justice were also the lawyers that represented the Alabama Policy Institute in the original lawsuit to have the Alabama Supreme Court rule the Alabama Marriage Amendment and Marriage Protection Act constitutional. So they had been in this case in a different capacity then. And we got along fine with those folks. I mean, we had cordial relationships. We, you know, exchanged information when we had to. Sort of a trivia interest. Matt Staver, who their lead counsel, was the dean of Liberty University Law School while I was a dean at Cumberland. We actually had some conversation. So you had 2 former law school deans on both sides of this thing. One thing I forgot to mention, just to go back, the Alabama Supreme Court finally, before the Chief Justice was charged and after his January 2016 order, issued a decision dismissing all of the petitions that had been pending in the API case after Obergefell. So that case disappeared at that point in time. So the first thing we do is file a motion for summary judgment in the Court of the Judiciary. The Court of the Judiciary operates under the rules of the Court of Civil Appeals, so we have the right to do that. The Chief Justice and lawyers filed a cross motion for summary judgment. August the 8th, 2016, we have oral argument in front of the Court of the Judiciary, and the Court of the Judiciary says we're not resolving this case on summary judgment and set us for trial in September. So in September we appear, and it's worth at least to get a flavor of the case what the steps of the Alabama Supreme Court were like that day. They were crowded with people. One area, and by far the largest area, were the people that supported the Chief Justice and his stand against same-sex marriage. In another area, but less populated than the other area, were people that supported the decision in Obergefell. But literally, the states of the Alabama Supreme Court were covered with people. But one of the worst things I saw, and I will always remember it, there was a sweet-looking little girl, 8, 9, 10, that had a sign which essentially said, "Sodomites will rot in hell." And that caused me to really think about what was going on. But then what happened next is something that happened the last.
Real quick question. At this time, the probate judges, are they issuing the licenses within the
Most
state?
of them are, some are not.
Okay, so it's kind of hit and miss
Yeah, but
within the
I think
state.
at that point, the vast majority were issuing same-sex laws. So this happened twice, the oral argument on August the 8th and then the trial. We go ahead and get in the courtroom early like good lawyers. The courtroom, this is the chambers of the Alabama Supreme Court where you try the case, because you have 9 judges. The place is literally packed with people. The Chief Justice's lawyers come in, and we exchange pleasantries, and they sit down. And at about 5 minutes of 9, the Chief Justice comes in to a standing ovation. And I'm talking to Ashby Pate, and I'm looking around saying, we may be the only people on our side in this entire proceeding. But it was clear that most of those people were there. And of course, the court was not in the room, so nothing inappropriate about that at all. So we try the case. We do not need opening statements because we'd already had a lengthy oral argument in August on the case. Our case consists of documents, the memos, the orders, those sorts of things. We rest. The Chief Justice testifies. I got to cross-examine him. At the end of that, Ashby Pate gives this really, really first-rate opening statement, which essentially tracks what I just told you. I give the closing argument, and am able to remind the court that 13 years before, in this same courtroom, the Chief Justice was on trial again for violating the canons of ethics. And I also got to plagiarize, and I told Judge Pryor that I was going to do this. He gave a wonderful closing argument in the first Roy Moore case that I essentially adopted because it's a great statement of the rule of law. So we rest our case, and a short few days later, the Alabama Court of the Judiciary decides that the Chief Justice is guilty on all charges. There are 2 pieces of evidence that I think are worth noting. The first was these memos that the Chief Justice sent to the members of the court trying to get them to rule that Obergefell did not apply in the state, and they did not. The second was on January the 6th, when the Chief Justice issued his opinion, the lead counsel for the Chief Justice, who was not representing the Chief Justice, posted something on the website of Liberty Counsel, which said, let me find it, in Alabama, state judiciaries are standing up against the federal judiciary or anyone else who wants to come up with some cockeyed view that somehow the Constitution now births some newfound notion of same-sex marriage. That was a critical piece of evidence because the Chief Justice defended the case on the grounds that he never ordered the probate judges to do anything. What he said was that it was a status update. And so we were able to show that his present counsel in January the 6th indicated that he was standing up against the federal judiciary at that particular period of time. So the September 30th, 2016, the Court of the Judiciary issues its opinion and says at the beginning, at the outset, this court emphasizes that this case is concerned only with alleged violations of the canons of judicial ethics. This case is not about whether same-sex marriage should be permitted. Indeed, we recognize that a majority of voters in Alabama adopted a constitutional amendment in 2006 banning same-sex marriage, as did a majority of the states over the last 15 years. Moreover, this is not a case to review or to editorialize about the Supreme Court decision in Obergefell, a decision that some members of this court did not personally agree with or think was well-reasoned. The court simply does not have the authority to re-examine those issues. What a wonderful statement of the rule of law and what the rule of law is about.